Back into index pointing right, and there it is, a quick guilty plea. Notice how the judge immediately confirms if it's freely and voluntarily. That's not just politeness, it's a legal safeguard. Every plea has to be made without pressure, ensuring the defendant knows exactly what rights they're giving up.
Good morning, sir. Are you Michael Barrelli? And will your client waive the formal reading of the indictment? Mr. Lesser, I take that. Okay. Mr. Barrelli, can clause number 25, DCCR 0003, state has elected to proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents have your signature on them that the state has marked as Exhibit 1. Before you sign these, did you go over them with your colleagues? Do you fully understand? And do you understand, if I follow the agreement that you've made with the attorney, that you will be waiving giving up any right to appeal? And are you a U.S. citizen? State tenders number 1. It's admitted. Is there any evidence that you're Barrelli can talk about? Alright, sir, I'm going to find that you entered the plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and if this...
Simple words, but huge consequences. 180 days, that's 6 months in county jail. Sounds light? Not exactly. For many, misdemeanor time still means lost work, reputation damage, and a criminal record that follows for years. The court here moves fast. Justice served, or just another day in docket traffic.
Time find you guilty of the Class A misdemeanor with property property. Sentence you in accordance with your agreement to a term of 180 days in Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right. They're handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived the right to appeal. Good luck, you sir. Good morning, dear Juan Sanchez. And Mr. Sanchez is on probation in clause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was unagreed, there was no deal, and I received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
And I have received some objections filed, comment and objections filed by Mr. Franklin, Mr. Nichols. Do you, does the state have any objections or corrections to the updated report? And so with regard to Mr. Franklin, typically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time. I'm not really going to take that into serious consideration. So it's not something that's going to make a big difference in what I do today or not do. That one, yes, injection granted. With regard to number 2, which has to do with a note front in the record that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on the criminal history could still be potentially denaturalized, deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what it will do.
What do you think? Balance scale, this part's fascinating. A defense objection claiming racial bias in the probation report. The judge carefully acknowledges it, but overrules, emphasizing fairness and context. This shows how judges must balance perception versus procedure, because even subtle wording in a report can affect sentencing tone.
In the case, I understand your position. Honestly, with criminal history, I know with another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So, overruled. Um, with regard to the fact that his prior convictions are inadmissible hearsay and to revoke, in any motion to revoke probation or any case, uh, they may prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were. I understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving intoxicated to get where we are now. And so I'm going to in regard to the prior conviction. Any witnesses today, either party, may have a witness.
I know me. Your Honor, we previously
Yes. Yes.
We have filed a, they have been reviewed by the court, for consideration. Well,
I will, and I did. Hold them up again, just.
Specifically, they were not any service for law.
Okay, that's right. Thank you.
Line.
Okay.
The letter is for
Thanks.
speaks to my client's care.
Yes.
Support by
I see them right here, and I did review them obviously from that, and we'll take them into consideration for hearing.
Thank you.
Anything else?
Your Honor, I'm not on the the analysis of the court of ruling and rejection. Point out absolutely the alarm. There is a time in which the fire ended. And
Sure.
we have the court we looked at from 2001 to
Yes.
and then by the admission of the probation officer, Sanchez has had simple violation, not a supervision problem, made to be made up to compliance with probation. And although he did prove true his current violation, he has shown 5 years continuing compliance. And the gap for the gap, the 5-year compliance, that's factored to keep him on action.
Thank you, Mr. President. Mr. Nichols.
Your Honor, usually plans that. Our analysis has been mostly well information. Make a decision. I agree.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it out again. You got this DWI, so you had there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018. Now we have another DWI that you have committed to in another county where you were driving the vehicle without the interlock and under the influence. And
Fire now, we're entering the emotional core. Repeat DWI offenders. Listen to the judge's frustration. We're lucky this isn't manslaughter. That line hits hard. It's a reminder. These aren't just paper crimes. They're potential tragedies waiting to happen. Every repeat DWI feels like a gamble with public safety.
at this point, I feel like we're all lucky that you have not, that we're here on the DWI, not an intox assault, manslaughter, or something like that. At some point, you've got to figure it out. You're on probation, the same officers. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full count. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation. The main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin. This shows this was not an agreement, so you do have some rights to appeal. Once y'all sign that, I'll get a copy for y'all if y'all sign this bottom. I'm also going to hand you a written admonishment regarding the ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment. Here's the wrong with that. This is just too focused, so it doesn't pile up. Yeah. Bottom page of y'all. That's okay, as long as my six came through. I'm okay, because I get the top two. Give me one more. Yep, you're good. Thank you. Alright, sir, you can go back with the vote. Good morning, sir. You're Alfredo Gayton. Mr. Gayton was previously in court and caused on the 25 DCCR 0184. Entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that?
Have, Your Honor.
Are there any additions or corrections?
No, there was.
All right, Mr. Parker, you may proceed.
My client's knowledge, I'm giving the court and prosecutor a direct report from Frank Nader.
And I've received that and reviewed it as well.
And, Your Honor, talk to this man, know him. He is a person that's the alcoholic. And I think he was, I think he was, honestly, PSI and talking about everything he did, 11, 14, to the point where he drank. He used 12-pack regularly, he got tequila, roll regularly, till the point where he passed out, never did enough. So he's got WWI, never had any kind of help at all. And I think he is a prime candidate for getting it on. He paid drug carry, where he's trying to do it on his own, and he was somewhat 17. He took the Bradford with it, put it in Belmont. He has work, he has the ability to make money, but he's getting out there and get information. and build the safety program. So he can't do that. And I think it looks like to me that he is kind of also current with the identification. And I think this is important as well.
Thank you, Mr. Carter. Something else? I think it goes without saying how
Yeah, I mean, I think that's it's true, you know, so many people have got the opportunity to work for them, and, you know, not anybody wrong. Each of them got to go. Okay. You know, you want to go to work.
Broken heart, you can feel the pain in this moment. He's not a villain. He's a man fighting addiction. But the law doesn't always separate the addict from the act. This tension, compassion versus accountability, defines so many courtroom battles. Should justice punish or heal? Clapping hands, this is rare. A judge giving a zero-tolerance probation after multiple DWIs. It's both a lifeline and a last warning. One slip, and it's straight to prison. You can sense the gravity, redemption on a razor's edge. What would you do if this were your last chance at freedom?
But if you've gone to prison 3 prior times for DWI, 3 times you've gone to prison. This is your 4th felony DWI. This is your, some point when you get out of prison, do you say, I need help, and I'm going to get help for myself, instead of saying somebody else did it, help me? I know, but you have people like Lloyd, you attorney made it. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison. Right.
Yeah, well, clearly, I think when he came here, he was looking people around him. There were some things that he was not drinking. I remember the incident that there was an episode where he started drinking again. It was pretty close to the time frame this. This was the only time he started drinking again. And I don't think that he was blaming anybody for not getting out. Just that he's never had an opportunity. And, you know, when you're an alcoholic, maybe these things easy, you know, to say. The same thing with an abused woman. Why don't you just leave? Why don't you just leave? Learn.
But
it's hard, yeah.
I don't disagree that it's hard.
And
but I also, if you'd never been to prison before,
right.
And if you hadn't had kind of the wake-up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out, and then you do it again. Well, I didn't figure that out. Let me go do it again. Your blood alcohol was 0.257. You ran off the road. I mean, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is has killed someone or hurt someone, and the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County, you know, if you were given an opportunity. At some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier. It's odd to me that there is not probation.
Some of these jails looking at the bottom out, one of the deals, you know, leaving 2 years before I'm not having the number shut. So,
I mean, you got 12 years back in '04. 12 years for your DWI, second felony DWI. Then you got another one after that. For some reason, Bexar County said, well, let's give them less time. Let's give them 5 to reward them continuing the wrong behavior. Anything else?
yeah, I just think that I just see people that come to, you know, our hospital so long, in fact, it's criminal use, alcohol, they're going to be seen on their 4th, 5th week release, so you're considered on probation. You're on probation, DWI, you violate the terms of probation by drinking, and you come back for, I mean, all these courts, and several times we say, hey, that's good, if you say, you know, not to make it seem hard, you know, what the court, you know, and I don't, I get it, but I don't believe that. I just think he's a fine kid, so he's benefit from it, he's a good person, he'll work, and you know, yeah, I just think this.
Sure.
So,
Sorry?
if you don't do
You've been sober since the accident?
I went to a chair that was in the bottom, and she ran, she just walked, she was, shocking. So, there's no, who's the whole, well, also the,
Okay, slow down.
he's one of the only ones that would get an opportunity, he knows he's serious about it, he's like, allow him to do it, he's probably, you know,
So, here's the thing. If I even were to consider, I'm not sure why I'm considering, but I'm like, giving you a probation, you would not drive ever. I mean, it would be part of your probation. So you're going to have to, I mean, it would be a condition of your probation that you never drive the entire time that you're on that probation. I mean, you understand that? I think we should clear what's like, and so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation unrestricted, and I lose my opportunity that I have today to give up to 14. Yeah.
One thing we could possibly use is 17 to kill over 10, give them 180 days up front, and hold that to the end. Is it condition? I mean, let's just think it more.
No. I don't know that it really sense the time. Just give them
Right.
essentially. Okay. Here's what I'm gonna do, Mr. Gates. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence you're given. I will make a notation. You will not plea agreements on a motion to revoke your probation. If you violate, find that you violated, that's it. You're done. You understand? So I'm going to sentence you to a term of 10 years in the Institutional Division of the Texas Department of Corrections. But I'm going to suspend that. You're on probation for 10 years. I'm going to order as a condition of your probation that you enter successfully complete the safety program, and that when you're released as part of that aftercare, you will then enter and successfully complete the JCDI program. This is outpatient. You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That device will tell me if you have alcohol in your system. If you test positive on that, when you get out after safety and you test positive for alcohol, you will immediately be back in here for 10 years. It's the length of time that you have been an alcoholic. This is going to be a very difficult process. But either you want to do it and go through that difficult process, or you want to spend the rest of your life. So that's going to be up to you. There's no relapse, and it's a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get some time in while you're waiting to go to safety. Anything else, condition-wise? Anybody can think of? I'm sorry. I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Dayton, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it because, again, this is the only opportunity